co-counsel, Rachel Duffy, represent the respondent, Mr. Price, in today's proceedings. I'm arguing that the 14th Circuit below properly extended common law, conduct-based foreign sovereign immunity to Mr. Price, and my co-counsel, Ms. Duffy, is arguing that Mr. Price did not exceed his authorized access under the Computer Fraud and Abuse Act. To the first issue. This court should find that the courts below properly held that Mr. Price is entitled to immunity and is shielded from suit in United States courts for the actions that he took as an agent on behalf of Saudi Arabia for two reasons. First, this court and several circuits have already rejected any argument that common law conduct-based immunity cannot exist when a plaintiff sues a foreign agent in their individual capacity. And the fact that Mr. Price is a U.S. resident and citizen does not foreclose his claim here. And second, each of the three requirements under Section 66 of the Second Restatement of Foreign Relations Law, which the parties stipulate governs this case, are satisfied, because exercising jurisdiction over Mr. Price would have the effect of enforcing a rule of law over the Saudi government. And to my first point, the 14th Circuit below properly found that governing case law and the practice of the United States confirm that common law conduct-based foreign immunity applies in individual capacity suits regardless of that individual's citizenship or residency. The purpose of common law foreign immunity is to shield foreign states from suit in United States courts, and according to the Fourth Circuit in a 2012 case, Yosef versus Samantar, conduct-based immunity specifically is premised on the imputability of the acts of an individual to the state. Thus, under this doctrine, a person...
Can I ask, what is the impact on Saudi Arabia here? They've already paid the money, they're not losing anything, they're not part of the lawsuit. Doesn't that mean that all the company is doing is trying to go after the United States citizen here alone, and they're not doing anything with respect to the foreign country?
Well, Your Honor, the exercising jurisdiction over Mr. Price would have the effect of enforcing a rule of law against the Saudi government, because adjudicating the merits of this case, as Your Honor pointed out earlier, would inherently call into question or pass judgment upon the Saudi government's actions, and it would do so by passing judgment on Mr. Price's actions that were taken in furtherance of a legitimate government objective that the Saudi government had. And specifically, as this case is styled under the Computer Fraud and Abuse Act, the entire idea is that it allows redress against all who conspire to commit a violation of this act. So that would naturally require an analysis of the Saudi government's involvement here.
I have two questions today. First, why is a separate branch, shouldn't we simply defer to the State Department's view in these matters? And then, why don't you address that one first? And then secondly, aren't immunities like privileges something, doctrines that should be applied in a limited fashion, in a careful fashion, and not allowed to be applied too expansively? And isn't this being applied too expansively for this court to go where it has not gone before? I don't think any circuit court has, except in Butter, which is a questionable authority. Why should we go there?
Well, Your Honor, to your first question, this court in the 2010 case, Samantar versus Yosef, did instruct that in the second step of the analysis that governs these claims, the court should look to whether it is the established policy of the State Department to recognize this ground for immunity. However, there is no established policy here, so that cannot cut for or against Mr. Price's claims. The State Department has filed suggestions of immunity in personal capacity suits, such as this one, and in none of those suggestions of immunity did the State Department focus its inquiry on citizenship or residency or really any other factor specific to the individual defendant, and rather looked at whether the conduct alleged was taken in an official capacity. And here, ZTEC does not even deny that that element would be satisfied here. And to your second question of why we should not extend this doctrine to United States citizens.
Why shouldn't we restrict it here and not extend it? Go ahead.
Your Honor, The nature of immunity itself can help guide this question, because as the court expressed in Verlinden BV versus Central Bank of Nigeria in 1983, common law governing immunity is regarded as extending virtually absolute immunity to foreign states as a matter of grace and comity on the part of the United States. And as the Fourth Circuit decided in Butters versus Vance International in 2000, it is but a small step to extend that immunity to United States citizens. And although
It feels like a much bigger step though, doesn't it? I mean, that feels like a gigantic step. Essentially, what you're looking for here is to let a US citizen paid by a foreign government spy on a US company and completely get away with it. That feels like a really big step.
Well, Your Honor, extending this immunity to Mr. Price would simply be furthering the principles that underlie the doctrine of immunity. He was acting as a foreign agent of the Saudi government, and he was doing such conduct in furtherance of legitimate government objectives and protecting foreign governments from suit in the United States courts for such behavior and such conduct is the very idea of conduct-based immunity here.
Counsel, if we adopted your rule that you want us to apply, wouldn't every contractual relationship between an individual and a foreign government then be subject to sovereign immunity?
No, Your Honor, it would not extend to every contractual obligation there. For example, if the Saudi government a diplomat was in the United States and hired a taxi driver to take him to the agency, then...
So what makes it then in this case? What is it about? Is it what Saudi Arabia is looking to do?
Yes, Your Honor, that's exactly right. It's
All
looking...
right, and then from a policy perspective, why should we grant sovereign immunity in those situations? Because you're asking us to apply a common law principle. So why from a policy perspective should we do that?
Well, Your Honor, adopting a rule here that only affords narrow protection to the agents of foreign sovereigns could instigate retaliation by other nations and cause foreign officials or parties acting as agents of the United States in other countries to be similarly stripped of their immunity abroad. And this could have far-reaching effects.
Give me an example of that. What do you mean by that?
Your
In a
Honor,
non-employer-employee relationship? Or what?
Your Honor, if an agent of the United States were carrying out the government's objectives in another state, and that state was found out that this court were not willing to grant immunity to their agent, they could strip the United States of that person's agency as well and their immunity from suit
But
there.
wouldn't that be in their court, not in our court?
That's
Doesn't it presume that other states have immunity provisions in their codes rather than common law, similar to our common law immunity provisions?
Your Honor, yes, that did assume that they would have similar provisions, but there is immunity for U.S. agents recognized in other states, and that is why the United States also grants immunity to foreign states, because it is this idea of grace and comity. And to strip a foreign state of their immunity simply because they chose an agent who happened to be a citizen of the United States could have far-reaching effects in intelligence gathering and counterterrorism operations. And it comes...
Isn't comedy a matter for the executive to determine rather than the courts? They're in the business of comedy. We're not. Or am I wrong about that?
Your Honor,
Yes, dear.
I apologize, Your Honor. All of the branches should recognize that this is an important principle that should be upheld. And although the executive branch, if it were to have an established policy, that would be instructive here. There is none. And the executive branch and the State Department had every opportunity to step in and say that it did not want Mr. Price to be immune from this suit because he's a U.S. citizen, but that hasn't happened here. And instead, the State Department has remained silent, and there is still no policy saying that he should not be entitled to such immunity here.
And that State Department statement sort of weigh against Mr. Price. I mean, there is none. He could have sought one. He didn't seek one. Why doesn't that weigh against your client?
Your Honor, because as this court explained in Samantar, the the weight that should be given to the State Department's view here would only turn on their established policy. So the lack of established policy, the lack of intervention here on the State Department doesn't necessarily cut for or against Mr. Price here, especially considering the fact that all of the other elements of Section 66 are satisfied here, and considering the fact that exercising jurisdiction over Mr. Price would be enforcing a rule of law. And as this court stated in Salmantar versus Yosef, suits against individuals such as Mr. Price should be treated as actions against the foreign state itself, as the state is the real party in interest. And this lawsuit is a prime example of how a claim nominally against an individual can target the alleged acts of a sovereign. Petitioner's central allegation here is that Mr. Price assisted in carrying out a clandestine operation ordered by the foreign sovereign. And to read Section 66 as turning on whether the plaintiff in such a case is seeking compensation out of the foreign state's funds is overly restrictive. Enforcing such a requirement and allowing immunity to be evaded entirely by merely pleading damages against individuals rather than the state they act on behalf of would render the entire doctrine of foreign immunity illusory. And a narrow interpretation, such as petitioner poses should be adopted here, would categorically exclude individual capacity suits, and therefore eliminate the doctrines of both conduct-based immunity and foreign official immunity entirely, which are both premised on the idea of extending the immunity of a foreign state to its individual agents. And this would require this court to reverse its decision in Salmantar, which specifically said that suits against agents and officials are cognizable under the common law. And in addition to both courts...
Is he really an agent of Saudi Arabia? I mean, they paid him to do this, but, you know, does that really make him an agent?
Yes, Your Honor, he would be an agent here in this case because they paid him to take under conduct that was furthering its legitimate government objectives here. He was hired to do...
Is that the analysis, the furthering the government objectives, that gives him agency status?
It should be under this doctrine of immunity, Your Honor, because this doctrine of immunity is premised on the conduct that was undertaken, not any characteristic of the individual. So here, when Mr. Price was hired to do something that the Saudi Cyber Intelligence Agency would have done on its own anyway, he was hired to do the very government's work and further its interests.
Well, he didn't have to carry it out if he didn't want to. They just said, if you do this, give us this, right? If he didn't do it for them, there was no breach, right?
That's correct, Your Honor. There would not have been a breach of his contract if he chose
So, I mean,
not to.
there's not a lot of control going on there, or that, you know, reporting weekly, this is what I'm doing.
That's correct, Your Honor. However, when Mr. Price completed this task that he was asked to do by the Saudi government in order to help them combat online terrorism, he was paid for that work, and he continued to provide...
That's actually a question that I have, and I think I'm Boone for bringing my attention to it. Was he being paid for the work, or were they just paying for the product, right? Like, it feels to me like, you know, it wasn't like he was getting installments or anything along those lines. He wasn't being paid for his work. He was selling them a good. And if he's selling them a good, doesn't that make it so that he's not an agent?
Your Honor, I think he was paid for both. He was paid for his work in finding the vulnerability in ZTech software, for creating this program, for giving that program to Saudi Arabia, and then for continuing to provide ongoing tech support as he has.
But he was doing that already for ZTech, so why isn't he kind of like the taxi driver? He's taking the government agent somewhere in furtherance of the government agent's duty, but, you know, using your analogy.
Your Honor, this would be a little bit different because although he was already looking for the zero-day vulnerability, he then used that information and created this software that would help combat terrorists in using that application. And by doing so, and by continuing to support the Saudi government, continue to instruct them on how to utilize this software, he had an ongoing relationship with them beyond just handing over the software. And
What did you, go ahead, Judge. Judge Wilkins, go ahead.
Oh, I didn't have a question, sorry, I see that she has about 10 seconds left, so I was gonna let her wrap up.
And for each of these reasons stated, because this conduct-based immunity does apply to individual capacity suits regardless of citizenship or residency, this court should find that the courts below properly extended immunity to Mr. Price, and this court should affirm. If there are no further questions, thank you very much.
Okay.
Thank you, Your Honors. May it please the Court. My name is Rachel Duffy, and along with my co-counsel, Ms. Lumley, I represent the respondent, Mr. Price, in his defense against the petitioner, Z-Tech. Mr. Price cannot be found liable under the Computer Fraud and Abuse Act, or the CFAA, because his conduct in this case does not meet the definition of exceeds authorized access under Section 1030A2 of the Act. Under this section of the CFAA, individuals will be held liable if they access a computer without authorization or by exceeding their authorized access. This court should rule in line with the 4th, 9th, and 2nd Circuit's correct interpretation of this act, which focuses on whether an individual had authorized access to that particular computer information. Here, Mr. Price had the required authorized access to Timcan's computer program and any and all zero-day vulnerabilities therein, as reflected on page 3 of the record. Therefore, Mr. Price had the required authorization to access the zero-day vulnerabilities in Timcan and cannot be found liable under the CFAA. This brings me.
Excuse me, in other words, we ignore entirely the history of this statute, the legislative history, and the title of the statute itself. We pay no attention to that.
No, Your Honor, this would bring me to my second point. Prior to the 1986 amendment, the CFAA did have liability attached for purpose-oriented applications. However, in 1986, Congress removed that specific language. And as the United States District Court for the District of Columbia stated in 2018 in Sandvik v. Sessions, it's notable that Congress did not transpose the existing purpose-oriented language into the definition section, but instead it replaced this language and focused instead on authorization to access particular information.
Counsel, what do you say if the House and the Senate reports that give a contrary interpretation?
Your Honor, although